Hello everyone. Good morning, good afternoon and good evening to you, depending on what part of the world you are joining us from. My name is Freesia and it is so good to have so many of you join us today for the Global Privacy Law Handbook launch that we are presenting to you virtually. Bringing all of us together on this platform are two organizations that have brought together the world of advertising and the principles that guide it. I'm talking about the International Advertising Association and the Global Advertising Lawyers Alliance. As the world moves to more and more digital practices in every walk of life, social networks, they continue to revolutionize the way people communicate. Business processes and social interactions, they revolve more in the cyberspace. However, as these cyber interactions grow and more technologies come up, the users at large, they become more exposed, and that could infringe on their personal privacy. This is where the various privacy laws enacted across the globe come in. So to shed more light on this, and of course, formally welcome all of you, may I please request Ms. DAGMARA SZULCE, IAA Managing Director, to say a few words. Over to you.
Welcome everyone to International Advertising Association's launch of the Global Privacy Book. Today the IAA, in partnership with our global strategic partners, the Global Advertising Lawyers Alliance, is honored to have you join us as we introduce this new resource and our distinguished guests. The International Advertising Association was established in 1938, and today it is the only global association that represents the interests of all spheres of the marketing and marketing communications industry across 56 countries. For over 80 years, the IAA has played a strong role in supporting key industries issues such as freedom of commercial speech, self-regulation, and responsible advertising that puts consumer interest over everything else, like in digital privacy. We partner with GALA to develop the first ever global privacy book, as we felt there was no global consolidated research readily available to the industry to serve as a helpful guide in the very fragmented privacy regulatory space. We are very proud that today we are launching this first of its kind compendium of privacy regulations gathered from around the world, and we are fortunate to have with us today Nitin Pranchpe, the Chief Operating Officer of Unilever, one of the largest advertisers in the world, to unveil this book. The handbook covers issues relating to the privacy laws of 80 countries, and global corporations like Unilever will find such a book to be of immense value. The launch will be followed by a panel discussion led by IA Global VP of Corporate Affairs, Carla Michelotti, on how to intimately engage with consumer in the post-COVID era. We want to thank our partners at GALA for making this comprehensive project a reality. Thank you very much.
Thank you, DAGMARA. While IAA continues to work towards all spheres of global marketing and marketing communications, the launch of the Privacy Laws Handbook today is a very important step that helps us understand how various countries are protecting their citizens. To talk to us more on this, we have with us Mr. SRINIVASAN SWAMY, IAA Chairman and World President. Sir, over to you.
Namaste. How the world has changed the last few months. I do hope the pandemic recedes soon and full normalcy is restored in every part of the world. In IAA's 81 years history, this is for the first time that we can't meet physically to celebrate an important event, the launch of world's first compendium on privacy, data privacy laws from 70 countries related to marketing and advertising. We have 2 volumes that together comprise the Privacy Laws Handbook, over 700 pages in all, professionally put together by some of the best lawyers representing GALA from across the world. Before I proceed further, it is my duty to place on record our sincere thanks to everyone at GALA, particularly Jeff Greenbaum, for his huge contribution. For over 8 decades, the IAA has focused on providing direction in an ever-changing world It has been at the forefront of protecting freedom of commercial speech, safeguarding consumer interests, and supporting this option to choose. IAA demonstrates its thought leadership in the field of marketing communication by offering directly or through its chapters continuing professional development courses through masterclasses, workshops, seminars, conclaves, conferences, and the World Congresses. In recent times, some of these events have been held on virtual platforms. IAA's website provides knowledge updates across sectors, cultures, and markets through articles and opinion pieces for the benefit of professionals. It showcases videos on topics of current relevance and importance. The IAA has taken several initiatives on the development of the next generation of young professionals so that they may understand the current complexity and what could be in store. It also accredits courses of 45 education institutions located in every continent of the world, making sure the course curriculum is robust and the recommended books are prescribed to students. On successful completion, the IAA provides certificates to every student. IAA supports advertising self-regulation and has indeed been a catalyst in providing self-regulating bodies pointers to start in few countries. It promotes sustainability and defends any attack on advertising relevance or importance across the world. Yes, it has stayed relevant and served the marcom industry well as a global compass of marketing communications. In the last couple of years, we have seen the rise in concern of consumer data privacy, and therefore different laws have been enacted in different countries. IAA members comprise marketing companies, advertising agencies, data analytics companies, and digital marketing tech companies. It thus serves the interests of everyone involved in marketing services around the world. It is therefore but natural for IAA to partner with like-minded institutions like GALA to bring out a well-distilled global privacy laws handbook. We are privileged to have Mr. Mithun Paranchpai, Chief Operating Officer of Unilever PLC, as a guest of honor and receive the first copies of the handbook. As is public knowledge, Unilever has the world's second largest marketing budget, which is in excess of $8 billion. It has presence in 190 countries. In today's digital world, when advertising flows seamlessly across national borders, it becomes important to understand the laws of those countries. This is where our privacy laws handbook come handy for global corporations such as Unilever. Nitin's presence today and his comments that will follow on the book will certainly add gravitas to this launch function. Thank you, Nitin, for very graciously accepting our invitation. Before I conclude, let me add my own welcome to all of you. I was told that we have people registered from 45 countries across the world, making this truly a global launch. Thank you.
Thank you, Mr. Swamy, for sharing those wonderful insights and reiterating how important this initiative is for both IAA and GALA. GALA, as you all know, stands for Global Advertising Lawyers Alliance. They have members that are located throughout the world with expertise and experience in advertising, marketing, and promotional law. And they have taken painstaking efforts to put this book together. So to tell us a little more about what went behind and what we can expect out of it, we have with us Mr. Jeffrey Greenbaum, Chairman, GALA.
Thank you for that introduction. And thank you, DAGMARA and Sundar, for your thoughts as well. I hope that, no matter where you are joining us from, you are safe and healthy. While the impact of the pandemic has been devastating, and there is uncertainty about the immediate road ahead, there is no question that it highlights how critically important it is for all of us to think and coordinate globally, both in matters of global health and otherwise. But more on that in a moment. I am very pleased to be here with you today, representing the Global Advertising Lawyers Alliance, to celebrate the official launch of our new book, Privacy Law, a global legal perspective on data protection relating to marketing and advertising. Let me tell you a little bit about how this book came to be. The Global Advertising Lawyers Alliance, or as we often refer to it, GALA, is an organization made up of advertising lawyers from around the world. With law firms representing more than 90 countries, from Argentina to Zimbabwe, GALA's primary goal is to educate marketers, advertising agencies, governments, and others about the laws governing advertising and marketing and the latest developments in this rapidly changing area. GALA holds educational events around the world. For example, last year we hosted events in Moscow, Lima, and New York. We conduct webinars. We write, almost daily, on our blog, which you can find at blog.galalaw.com, about advertising developments around the world. We publish special reports, such as our recent report on COVID-19 related developments. And the thing that brings us here today, we publish books. GALA's books survey important legal topics that impact global marketers. We have published a general treatise on advertising law, as well as books on special topics such as ambush marketing, green marketing, and the marketing of alcoholic beverages. We had talked for many years about publishing a book that specifically focuses on how privacy laws around the world impact marketers, but it took a visit from some of the folks from IAA to help get it off the ground. Although we at GALA had long been admirers of IAA's work, when I got together with Sundar, Joel, and DAGMARA a little over a year ago in New York, we realized that we were concerned about many of the same issues and were looking for ways to bring people together for a constructive global dialogue. Our conversation inevitably turned toward privacy and data protection. We talked about the challenges that marketers face when trying to comply with rapidly changing laws in a fragmented legal landscape where the business of marketing continues to evolve dramatically as well. We talked about the ways in which governments enact privacy legislation and the ways in which we could help them enact smarter legislation. How do you best protect consumer privacy while at the same time creating an environment that allows global marketers to thrive? While not surprisingly, we were not able to answer that question in our initial meeting, we did agree that an important first step was to better educate marketers and governments about how privacy laws impact marketing around the world, and about the different approaches that countries have chosen to take. With IAA's valuable input and assistance, GALA's members from around the world put together a more than 700-page book that does a deep dive into how privacy laws impact marketers in more than 70 countries. We believe that this book is the first one ever to tackle this topic in this way. Because the book was finalized before the pandemic, we're already thinking about what's next. Will the recognition that we have to think globally lead to more harmonization of privacy laws around the world? Will the need for data on an individualized basis in order to track and trace outbreaks lead to a willingness to forego a certain amount of privacy? Will the economic challenges faced as a result of the pandemic lead to a weakening of privacy protections? We're going to be watching these and other issues very carefully as we start to think about the second edition. Let me take this opportunity to thank all of the GALA members from around the world who contributed to the book. Special thanks to Stacy Bess, GALA's Executive Director, Daniel Goldberg, who you will hear from shortly, who helped lead this project, and Soren Pietzker and Georg Huber, who helped us coordinate our guidance related to the EU. I also want to thank GALA members who served on our organizing committee to help think through the topics to cover in this book, including Lyra Kaplan, Lixia Lin, Briona Long, Jamie Mantilla, Alejandro Masot, Alexander Milner, Denise Miranda, Oscar Molina, and Justina Jean. And of course, thank you to the folks at IAA, especially Sundar, DAGMARA, and Carla, who have been such great partners on this project. Now, let's get to the book. Thank you.
Thank you, Mr. Greenbaum, for your thoughtful comments. We've heard from the organizations, IAA and GALA, and we have heard about the efforts that have been taken to put the handbook together. And it is now time for us to see this for ourselves. Ladies and gentlemen, let us have a look. IAA GALA Privacy Laws Handbook comes in 2 volumes. One for the European Union, another for rest of the world. Important reference volumes for international businesses, for businesses to harmonize and comply with laws around the world. A forward-looking, future-ready Privacy Laws Handbook. for the first time in the world, that covers 70 countries. Ladies and gentlemen, that is for the first time in global history that we are witnessing the launch of the Privacy Law Handbook, which covers the current laws in force in many different countries. I hope wherever you are, you're joining me and others with a resounding round of applause. We're very pleased to have as our guest of honor today, Mr. Nitin Paranjpe, Chief Operating Officer, Unilever PLC, one of the largest advertisers in the world. Ladies and gentlemen, with great pleasure, I would now like to request Mr. Nitin Paranjpe to deliver his address.
Thank you. Thank you to GALA and to IAA for allowing me the privilege to be a part of this wonderful virtual book launch. And thank you, Sundar, for sending me an e-copy of this handbook. Now, I have to admit, this is my first virtual book launch, adding to the many firsts that I've had over the last few months, ever since COVID struck us and almost overnight brought the world to almost to a standstill, forcing each one of us to experience new ways of doing things, and along with that, many firsts. But boy, am I glad that we have this technology which enables us to connect and do things that till a short while ago were almost impossible to imagine. Virtual communication is almost the norm. So I'm not surprised that platforms like Zoom, which had just about 10 million users in the month of December, have now had more than 300 million users last month. And you can imagine what's happened to its market cap with the number of users that they've had. But with more users come more data privacy implications. And that brings me to the topic of today. Now, this is a subject which has attracted a fair amount of attention in recent times. In fact, governments across the world have been thinking in terms of rules and regulations of how do we handle data and the considerations around privacy. GDPR, something that all of us would know, is almost 2 years old, and it has inspired and has been the basis of many privacy laws across the world. But even as recently as almost now, we've had the California Consumer Privacy Act, which prohibits the selling of personal information without explicit consent. And the space is changing so much that even today, governments are working to understand this rapidly changing landscape that we find ourselves in. In fact, what I find most interesting is it's not just governments which are dealing with this. At the CES event that took place in January, which is the largest consumer electronics show, guess what a company like Google chose to highlight? Not some fancy gadget. They spoke about the privacy control options for their Google Assistant. That gives you a sense of how important the space is becoming. And since then, it's only become bigger because we've had COVID hitting us. And through COVID, we've had e-commerce taking off, digital engagement increasing, conversation and data moving across boundaries and borders. And all of that only raises the stakes on what it means to handle data and data privacy. And that's what brings me to this topic, this handbook, and the importance of what has been put together. I once again want to say that this initiative of putting together a handbook could not have been managed alone. It required, and so I'm so glad that IAA and GALA came together and brought together all the multiple contributors from across over 80 countries to put this piece of this handbook together. And the benefit of this handbook is unimaginable, actually, for brands, for companies, for advertisers, because it first helps increase knowledge and the understanding of privacy laws and rules which are changing. And not just the rules that exist today, it helps people understand what the trends are, what the developments are, both in the legislative space, but also in what the environment for enforcement in this area is all about, and that too across 80 countries. You can imagine how valuable that is for any brand, any company, but more so global brands and companies in the age that we find ourselves in. But in addition to just compiling the rules and regulations, I found something else quite interesting, that the handbook encourages everyone and almost accords a very different status to data privacy. It is treated as a fundamental human right, and that's a big thing for everyone. And that's something that all of us need to start embracing. Now, in conclusion, I don't want to speak a lot, but I really want to say that while this handbook has done a lot, there is an enormous responsibility for all of us to come together and all of us to start not just raising the bar on data privacy within our company, but also to use our considerable influence to shape how the standards of data privacy in the extended ecosystem that we are in, that within our own companies, that we bring in a certain philosophy which makes privacy by design the core tenet which we have in mind as we think in terms of platforms and technologies that handle personal data. And if we were to do this, we will get to a stage where we move away from just compliance to laws and regulation, but get to a stage where we start building trust in consumers and trust in society about how brands and companies start using their very important personal information. That's it really from my side. I know that there is a lot more that needs to happen before we can get to that stage, but I do believe that this handbook plays a very important step, a very important first step to get us off on this journey. Finally, congratulations to GALA and IAA once again for this very, very important initiative, and thank you for according me the privilege and honor of being here at this book launch.
Thank you, Mr. Paranjpe, for taking the time to speak to us today. It is definitely going to spark a lot of conversation in our chat box right now. And talking about the chat box, I hope that you are sending in your questions, because we're now about to hear from our expert panelists on the subject of how to intimately engage with consumers while respecting their privacy in a post-COVID world. Our panel today is packed with privacy experts, and moderating this one is Ms. Carla Michelotti, IAA Vice President, Government Affairs. A quick introduction to our panelists. They are Cecilia Alvarez, who is Facebook's EMEA Privacy Policy Director, Gauthaman Raghuthaman, CEO Aclis, the company specializing in blockchain in the marketing services space, Daniel M. Goldberg from Frankfurt Kernet Klein and Sells, who is a counsel in the Privacy and Data Security Group and a leader in ad tech. Carla, over to you.
Thank you, Frisha. This is really exciting. As an advertising lawyer, I'm very proud of GALA. As an officer of IAA, I'm so proud of IAA. We're making history today with this first ever book. Welcome to our panel of experts. Today, we're discussing the business challenge of how to thrive in the increasingly online marketing world, but also respectfully and accurately comply and navigate the global matrix of privacy laws. How can we maximize the potential opportunity that the ability to use data enables in today's environment? There is no debate that the need to respect consumer privacy is very real. We all care about personal information. We also care about the ability, though, to find content that we want and need on the internet without incurring additional fees. It's the data that's gathered very much by advertising that allows the internet to flow to work around the world. Of course, it's advertising then that supports the free press, free content. It supports the free internet. So it's the shared value of the data to both consumers and advertisers that is very important, and why it must be a responsible, balanced approach for gathering data and a responsible, balanced approach to managing personal data. So how do we navigate the privacy demands and expectations as data increasingly becomes the key important tool in the marketing mix? And I'm going to start by asking Cecilia this morning the question, key question. Cecilia, is the issue really about gathering personal, intimate data about consumers, the private data, or is the issue one of how that personal data is used? Cecilia.
Thank you very much, GALA, for your question, and thank you also, GALA, for inviting me to participate in the panel. Since I am European, I would definitely think that it is the latter. It better fits with what we understand as data protection as opposed to privacy. As you mentioned, data are useful to boost our digital economy, our digital society, and this includes digital health, and it includes digital education, and it includes digital banking, and of course, it also includes digital advertising. The issue should not be then to avoid the data collection or to avoid data sharing per se, but to focus on how this data gathering and this data use, including data sharing, is made responsibly. And the GDPR and other legislations, I will not, of course, sometimes the Europeans are very arrogant that we have invented the notion of data protection, but it is not true. But what is true, definitely, is that the GDPR has been inspiring other legislation sometimes that compose nowadays, I think, a privacy, a very large landscape. But all of these legislations are attempts to establish what could be a responsible manner, what looks like as a responsible manner to gather and use data. It has been mentioned before that data protection is a fundamental right, and as all the fundamental rights and freedoms is not absolute. And this is also something that is important, because sometimes we think that because this is a fundamental right, it's like freeze any opportunities to do anything. No, it provides us more responsibility on how we are going to deal with this information. When they are impacted, yes, of course, Carla, go on.
I want to insert and just put a little spin on that too, because you're talking a lot about GDPR. It's 2 years old. How does a company really thrive, though, while navigating all the rules of GDPR? It's 2 years old. Has it enhanced privacy for consumers?
Well, I think it has enhanced for all individuals and not only consumers, because it is true that the GDPR is not looking at the subject matter, let's say, of the regulation from a consumer viewpoint, but from a citizen viewpoint. And this embraces also your element as a consumer as well in the market. So in practice, definitely it has been a lot of awareness during these 2 years. It's probably one of the laws that have been most publicized. I have some colleagues from the competition angle or other angles that say, I would love that my laws are as publicized as the GDPR was. And definitely it was in the mouth of everyone, but not necessarily in the good sense, in the sense that we have passed from being ignored to being scared. And I think we need to be not in the ignorance and nor in being scared. I think we need to get educated in order to embrace what is a balanced and a forward-thinking approach to data protection. And I think there has been a false idea, because the motto of the GDPR is that you get more control on your data, that this equals consent. And consent is a very important legal basis, but it's not the only one. And sometimes it's actually the one that you should not use, because you put the burden on the user on certain things that you do not really have an informed manner to control an ecosystem that is really complex. I'm not talking about only the advertising ecosystem. Is definitely this is a complex thing. So the focus should be more on the safeguards that you need to place in order that the kind of activities that you are doing are actually serving the mankind.
And I should tell people listening, we have people listening from around the world today. I don't know if you've seen the chat, but there's people from all kinds of different countries. And so as questions come up from the audience, please send them into the chat. We have a very tight schedule, but we're going to try to answer questions. I want to thank you, Cecilia. That's a lot of information. We're going to come back. Everyone can jump in. The other speakers can jump in. I want to turn, though, to the United States. There's 50 different states. There's almost as many different privacy laws. We've heard about California. We've heard about something called Privacy for America, which has as its goal trying to create a uniform privacy policy and privacy law throughout the United States. I'm going to ask Dan, the American lawyer, what's going on in the United States, Dan, about privacy? What's going on in the United States right now?
Yeah. Thank you, Carla, and thank you to GALA and IAA for the opportunity to help put together this amazing book, which I think is such a great resource for everybody. So Cecilia had a great point there talking about GDPR, and Carla is the question you asked. GDPR really has been, I think, a huge inspiration. It has had a fundamental impact, and you've seen that with the advancements in U.S. privacy law. You go back just a few years, and really, while there were a number of laws, U.S. law has been sectoral based. So you have laws governing health data, very specific types of health data. You have laws governing children's information, COPPA, but you haven't had the type of comprehensive law at the federal level that you really do in the European Union and in many other jurisdictions. And so in a way that's changing by California. California has this new law, the CCPA, the California Consumer Privacy Act, and that law has very comprehensive protections. Now, that law is at a state level, right? But because California is such a large community and there are so many people within it, you have to, if you're thinking about compliance with US law, you have to comply essentially with California law, which is set the minimum standard. Now, in terms of a federal law at this point, there is not really one that's comprehensive. There have been pushes to do so, as you were saying, with Privacy for America. But at this point, I haven't really seen anything gain traction. You've seen a number of different initiatives, but it's very politicized right now. You have different arguments, which are really causing issues with respect to passing a law like that. So you have arguments around preemption. Should a federal law preempt state laws? You have arguments around should there be a private right of action? And so at this point, we're kind of in a middle ground where I'm not sure we're going to see a federal law at this point, but we are going to continue to see state efforts. And so what we might end up seeing in the over the course of the next several years are other states following suit of California. And California itself actually already has another initiative that will be on the California ballot later this year in November, the California Privacy Rights Act, CPRA, which would give additional protections.
And so, there is a little election coming up in the United States this year. And so political policy may be stalled as this election goes forward. The global privacy book that we're launching today has a compendium of laws from over 70 countries around the world. But branding is without borders. Marketing is without borders. Internet is without borders. We live in a huge borderless internet world. Should the global advertising industry be hoping for a more uniform approach rather than 70 plus different laws? Would greater uniformity be helpful? How can business thrive in this environment? I'd really like to hear from all of you. We haven't heard from, maybe Dan answer first, but I'd really love to hear from all of you. How can we continue to thrive when we have a whole book on all the different rules?
That's a great point, Carla. It's really tough for advertisers right now. And that's why I think this book really is such a great opportunity here, is that it does break down what the different laws are in the various jurisdictions from a very high level. One of the big issues here is that we just have to figure out how do we comply with all the various jurisdictional laws, and they don't always coincide. So Cecilia mentioned GDPR has different obligations with respect to data. Some of it is based on consent. There are other lawful bases. In California, we don't really have that concept. And then there are obligations around do not sell, and sell doesn't have the meaning that you would think it would mean in the traditional sense. And so I think as an industry, we need to work together to be thinking about how do we come to a place to address the various laws in the various jurisdictions. And what we've seen are companies either looking at it really from an approach of going at each jurisdiction, or taking kind of the lowest common denominator to say, here's GDPR, this kind of sets the global standard around the world. We need to make sure that we comply with GDPR, and everything else will follow suit.
I want to turn to GMAN, because we've been kind of occupying the airspace here. The cookie has historically been linked to targeting consumers. Self-regulation has very much focused on giving consumers greater control where it exists in the privacy arena, has focused on giving consumers greater control, access, and transparency over cookies attached to the advertising. But several browsers have very publicly announced that they're doing away with their third-party access to identifiers. They're going to do away with cookies. So GMAN, what happens? The cookie is going to be crumbling. How does this impact privacy?
Thank you, Carla. Good question. I think it is. I'll start in a very proverbial manner. In the beginning, there was only context, and context was everything. I think the cookies came in later with the primary purpose of providing enhanced personalization. But somewhere down the line, the personalization took precedence over privacy. And that's where we are today, where the role of the cookies are being questioned right now. And it is equally important to note that we're only talking about third-party cookies and not the first-party cookies. And it's a very subtle but an important difference. For example, if you look at it, imagine if you're going to a shop to buy some goods, and somebody else who is not belonging to the shop just walks in and starts giving you recommendations. You wouldn't like it. You would rather prefer it from the shop owner. And today it has reached a stage where somebody else comes and rings your doorbell and gives you another recommendation because you walked into the shop. So that's the kind of intrusion that third-party cookies have gotten into it today. And the browsers and the industry is now trying to get to the situation of ensuring that it is not a troll or a snooping around without consent. I think what Cecilia mentioned about, it's all about consent. As long as an individual is given a consent to use their first-party data, it's fine. And when they are going to really use it outside that consent, it needs to be moderated. It needs to be maintained. So to me, proverbially, the cookie crumbles. What it means is that there will be reduced personalization from today. I would say less snooping, in my view, reduced personalization, and enhanced use of first-party data. I think the world will move towards better use of first-party data, but may have to compromise on personalization.
I'm going to ask you, because of your experience and your company, GMAN, more technical question. What about the browsers? Are we facing a browser crisis as a result of the differing infrastructures? Does removing the cookies, when you remove the cookies, does it mean that the information is not going to be tracked? And how can we as an industry return to, as Cecilia was talking about, trust, accountability, respecting consumer privacy in this new infrastructure without third-party cookies? How do we maintain or create and enhance the trust with consumers without cookies?
Yeah, I think the good questions. In my view, my advice will be for brands and the platforms to get ready for a world which is browser agnostic. We have to get to the reality that there are going to be multiple browsers. There will be, and in fact, in an emerging markets, in many other markets, people are moving towards mobile phones more than the desktop. So consumers are going to interact with or enter online, not just through browsers, but through applications as well. So I would like to see what Google has done with their privacy sandbox, more of a preparedness for them to get ready for the compliance, because they are just following what Safari and Firefox has already done. Safari and Firefox had already taken care of removing the third-party cookies, and Google is now getting ready to be compliant. So we need to really look beyond the browsers, and we need to really look beyond a situation where it is about first-party data and how we use it in a much better manner for audience targeting, and ensure that we build the necessary infrastructure where we work with multiple browsers to interact with, not just one browser. So that's the important thing to do.
Very good. Very good. Thank you. I don't think it can be said too often about how important data is. The data that gathers advertising, the data gathered by advertising helps support the free internet, supports free content, supports the free press. And we need to have this shared approach, a balanced approach to manage privacy and manage the data. And we need to adhere to something. We've talked a lot about this responsibility and the management of personal data. We have people on this call from around the world, but there's many, many countries. We've talked about Europe, we've talked about the United States. The book has 70 different country rules, but there's a lot of countries that do not have privacy laws. What happens there? What should the industry do? Are there guidelines? Should the industry be working towards self-regulation? I'm going to start quickly with Dan, but I'd like to hear from all of you. What should we be doing?
Yeah, so industry, so specifically the advertising industry, has been doing a lot over the last number of years. You know, going to what G-Man was just talking about around cookies, figuring out what's next. For example, IAB has been working on Project ReArc to try to construct a way to go, how are we going to deal with this cookieless world with respect to third-party cookies? And it is a really complex issue. And so what I would say to those brands that are focused in jurisdictions where there may not be laws is that despite the fact that there aren't laws, you should be thinking about reasonable expectations of the consumer. Would a reasonable consumer think what you're doing? Would they actually believe that you would be doing what you're doing, right? And so even if there are not, again, baseline laws, we as a community have a responsibility to make sure that we are taking measures to protect that data and use the data in ways that meet consumers' expectations.
Cecilia, you work in a global environment, a huge global company. What do you think industry should be doing as far as, should we be establishing law, establishing guidelines?
Well, based on my experience, not only in the current company in which I'm working, but also in other big multinationals in which I have been serving, when you are building a global privacy program, you cannot be thinking of not applying your global privacy program in a country just because they do not have laws there. So, because at the end of the day, it's being a good citizen or a good corporation, in the sense that if you really believe that this is a fundamental right, it is fundamental irrespective of the nationality of, in this case, the users, that this is going to be affected. Therefore, I think that the common of the basics that we have in GDPR and other laws that are based at the end of the day in respecting the dignity of human being is not the detail of the GDPR. It's just the basics, the foundations that are there. I would tend to think that any big corporation will be applying this irrespective of whether there is a law that obliges you to do so.
Yeah. G-Man, very quick, because I have another key question before we go to another exciting portion of this.
I'm just building on what Dan was talking about, Carla. I think self-regulation is a must, but the reality is that, bear in mind, internet itself is a decentralized network. And we're now getting into a situation where it is all about collaborating with multiple partners. So we need to find a way in which we need to strengthen company institutions or initiatives like Project ReArc with more representatives coming in, not just from platform owners, but from clients and marketers and other institutions to come together to create a framework that enhances collaboration. The problem is self-regulation is good. I mean, I can get myself very well and we can keep our companies very well. But the reality is that we have to work with another organization. And if they are not very good, it hurts you as well. So it is about collaboration. My mind, that's important to us as well. Yeah.
I want to, before we leave this for a second, I want to wave the flag of the International Chamber of Commerce Marketing Code. And for those of you on this call that do not have guidelines, you should check out the International Marketing Code and the toolkit to establish self-regulation, because they have some generic guidelines, very good baseline guidelines on privacy. The Global Privacy Book was put together before the COVID crisis that has impacted all of our lives. We're now witnessing discussion about contact tracing and sharing personal medical data. Do you think COVID, or how will COVID, in your opinion, very quickly impact privacy laws going forward? Anyone? Cecilia, Dan, and G-Man, and then we're going to introduce some additional speakers.
I think we have already. I have a very recent example. Yesterday, the German presidency of the Council, who is currently discussing the e-privacy regulation, so the next generation of privacy laws with respect, in particular, to direct marketing. Actually, they are proposing to the member states to discuss certain articles, and one of them has been particularly amended in view of COVID. With respect to the use of metadata, of electronic metadata, for purposes such as those that we have been and that we will be facing, not only with respect to the health threats, but also with respect to the economic reconstruction, because this has had also an economic devastating effort, and therefore we should think about also the two elements. I think that has an impact on organizations, on DPAs, also on the data protection authorities, and on the wider society. But I will leave others to also contribute to this, and happy to come back to any of these aspects later on, if there is any.
Dan and G-Man, do you want to add any comments here?
Well, I think it's interesting.
Yeah.
I'm just going to refer to, I'm just going to read it out. It's easy because it's safer. Look at it from Singapore's point of view, PDPC. It stipulates that the relevant personal data can be collected, used, and disclosed without consent during this period to carry out contact tracing and other response measures as this is necessary to respond to an emergency that threatens life. So we are now getting into a situation of a consent, which is a state responsibility more than a personal responsibility. And so it's a thin line of difference between surveillance and a contract to a society or a state, right? So there is no one rule and there's no one answer, but we need to find a way in which it is measured and erased after the activity is over. So
Dan, COVID will have an impact?
Yes, COVID has led to the collection of more sensitive health information. And so because of that, what I think you're going to see is the pendulum swinging back, might be within 6 months, could be within a year, when there's increased scrutiny around the types of data and how those pieces of data were used. They've been collected for the most part for very good purposes, but again, with increased data means increased scrutiny.
I now have the pleasure of introducing two additional special speakers, Soren Pietzker and Sundar Swamy. Soren is a partner in the firm Hooking Kuhn, Lure and Wojcik, and he can correct me on the pronunciations of the firm name, in Hamburg. He is that firm's EU GDPR expert. He is also the firm's EU privacy expert. He's the GALA privacy expert, and he represents Germany for GALA. Sundar, we met earlier today. Sundar is also chairman and managing director of the RK Swamy Hansa Group. And of course, importantly, he is the chairman of the International Advertising Association. Welcome, Sundar and Soren. Soren, I'm going to quickly ask all the panelists, how do you think COVID will be impacting the direction of privacy laws going forward, Soren? You're the EU GDPR privacy expert. What do you think the implications will be of COVID on GDPR and privacy?
Soren, you're on mute.
Soren is on mute, but we will wait for him to get off of mute.
Thank you, Carla. Can you hear me now?
Yes, we can. Thank you.
Well, for the EU, apart from what Cecilia correctly pointed out about the draft e-privacy regulation, which might get a big push now through the COVID because it still hasn't come into force yet, I do not anticipate a big change in privacy laws apart from that, but rather a greater sensitivity and perhaps even more acceptance for the already existing law, the GDPR. There's just one example here. People are being asked now to leave their personal contact data in many places, such as restaurants, hotels, hairdressers, and many other establishments where people gather. While they might accept that this could be necessary to fight the spread of the virus, and thus will most likely and deliberately provide their contact details, I'm sure they also want to be sure that the protection of their personal data is greatly secured.
I have a quick question and a fun question for Sundar. You must be very proud today of the IAA partnership with GALA and happy to be introducing the Global Privacy Resource book. I have a question from our audience. How does someone get a copy of the book, Sundar?
Well, if you're a member of IAA, you can actually get it for free. You will get an ebook for free And that's the privilege of being a member of IAA. You also can get a discount if you go to the IAA website to pick a copy of our book. And of course, it's available for everyone at Amazon. So, there are multiple ways to get it, but the best way is to become IAA member and you get a free copy.
A free copy that they can download.
They can download.
They can download the book, which is amazing. This is the first of its kind ever, a historical book. I have a question here for Cecilia. Cecilia, with you being a privacy policy director, this question is for you. How important of a part does data protection officer play in the entire framework? How key is the data protection officer given the GDPR responsibilities and outside of EU? The role of the data protection officer.
I am not a data protection officer right now at Facebook, but I was a data protection officer globally for another multinational. And I see and I work very closely to the data protection officer at Facebook. And I think he or she plays a key role, but he must be able to do this with the support of the whole organization. So you cannot be the data protection man or woman in isolation in your thing, thinking about the wonderful things that you can do. So you should be embedded into the way in which the organization works, and you need to get supported by leadership in order to be able to work with the whole organization and not to be seen as someone who is a stopper, but just an enabler. And for this, of course, there is a big part that the DPO should play to seduce, if I may use this expression as well, your audience. But definitely, this should be a very important vision of the company from the top, that this role is there in order to help and to embrace the data protection culture in the company.
I have another question for Soren. We've all heard about the drastic fines, Soren, that GDPR can impose for violations. In particular, fines on the newly impacted data processors, which you've mentioned, restaurants and hairdressing salons and different employers. Talk a little bit about that.
Well, absolutely. The threat is there, and there's nothing to joke about it. Fines can be very heavy, up to 10 or even 20 million euro. And here I would quickly like to talk about a recent case, which is not exactly COVID related, but shows how a slight oversight can lead to drastic fines. Until recently, unsolicited emails, although being illegal, were not subject to any fines in Germany. Only private consumer protection associations and competitors could ask for cease and desist declarations or contractual penalty clauses, or sue and ask for cease and desist orders. Only in case of subsequent violation, then penalties or fines could be issued, but they usually started around 5,000 or 10,000 euros, not millions. Now, in the case that I'm talking about, a healthcare insurance company sponsored a sweepstake and wanted to use the data also for advertising purposes, as they all do, as far as the person had given the required consent. So far, so good. However, by mistake, about 500 people who had not consented also received advertising emails. Now, the Data Protection Authority issued a fine of 1.2 million euros. And this, although the used data did not contain any sensitive health data from the insured, but obviously, and this was the reason for the fine, the technical and organizational measures to only use the data purpose-related, they were not sufficient. So this shows how slight oversight can lead to drastic consequences. But back to COVID measures and compliance here. As far as I've observed during a few visits recently in restaurants and hairdressers, etc., none of the business seem to actually be aware of the necessity to comply with GDPR. For example, I sometimes could even see the full list with all the contact details of customers who were there just before me. And also, for example, another case that I just advised, a production company wanting to shoot a commercial in Germany, and they were fully aware of the official obligations for precautionary measures, and had even developed their own COVID procedures, including a health questionnaire for every person entering the set. But definitely they needed some extra lessons in compliance with GDPR, because they were actually collecting and then processing the data through this questionnaire. Well, however, and I can speak for Hamburg only here, and the authority in Hamburg, the state of Hamburg, which is also the city here, they have not issued any fines yet, but they are watching whether the most important precautionary measures to fight the virus and the spread of it are being taken. But they have explicitly reserved the right to take further steps if need be. Not that I think that they would need to reserve the rights anyway, but that's what they did. And so my recommendation here, and this is the closing sentence for this question, and this is for everyone who even thinks of collecting any contact details from a person these days, at least at the front end, be the visible part of it. And by this, I mean the privacy policy to hand over when you collect the data. It should be in place, and you should make sure that no unauthorized person can see the collected data. And of course, everything you mentioned in the privacy policy, all the other technical and organizational measures at the back end have also to be in place. Thank you.
You know, going back to what Cecilia was saying, this ties into the very first thing that Cecilia was talking about in response to the first question. You know, everyone has to think about the use of the data, why the data is being collected, the use of the data. And under COVID, there's a lot more data being collected. I have a question here from the audience for G-Man, and I should explain to the audience I'm calling you G-Man because that's your name. It's a shortened of your name. According to you know, listening to you, privacy is going to become a very competitive differentiator, perhaps, amongst brands in the going forward future. Is that one of the understandings we should have from what you said, that privacy could be a marketing differentiator?
Oh, absolutely, for sure. The reason being that if a company is privacy compliant and they are honoring privacy, their ability to partner with another organization is much more better, and the chances of collaboration is much higher. And everybody would love to work with a company which is compliant. So to me, it's a no-brainer. It is going to become a big differentiator.
Here's an interesting question. And again, it's for G-Man, but any one of you can jump in. Do you think it's a huge setback for companies doing digital media campaigns on anonymous data? Is there a workaround, especially for giving a good customer experience? I don't know if we're talking about you know, companies all doing digital marketing campaigns on anonymous data, but it's a technical question. Is it a huge setback not having cookies, trying to get first party and anonymous data?
Yeah, it is not a setback. I think we should recognize that we are going to wear a different kind of spectacles to see the consumer. It's going to be high definition. So it's going to be much sharper and much better. As such, today, when we use cookies, we have a 50% strike rate only. So even though we have a cheaper CPM, it is only effective at half the price. Today, we are going to have a much better high definition consumers. They know them very well. So higher CPM, but higher strike rate. I would say you're going to get a much better return to your investments with sharper definition of audiences. So don't look at it as a setback. Get your privacy compliance ready and partner with good companies and do well.
And Carla, I just want to jump in here for 1 second. So I think the term anonymous is a misnomer, and I know it's thrown around a lot in the advertising industry. And what we think of as anonymous are identifiers that the law would say are actually de-identified, right? Or something that is hashed or pseudo-anonymized and might be treated under a different standard, but still could be considered personal data or personal information. So I think the big takeaway that brands need to have, right, is this idea that there are additional obligations around the data. It's not that we can't do things with the data or continue to use them for these purposes, but to understand that we can't consider those identifiers to be anonymous anymore.
I'm very glad you followed up on that word anonymous, Dan. Thank you. Thank you very much. For all of you, for Cecilia and Dan especially, what role, and for Soren, what role do you think self-regulation will play in this go-forward privacy world, if any?
So the Data Protection Directive and now the GDPR have contained provisions encouraging codes of conduct. But in practice, this has not I think, the expected goal. And we have very, very few codes of conduct that have actually been approved and on the pre-GDPR, and no one yet under the GDPR umbrella. This does not mean that there is no room. I think that the codes of conduct, in principle, should be there not to reinvent the wheel, but to adjust or to adapt the GDPR rules to specific sectors or specific elements that we have in the sector. So It's not something impossible, but definitely I think we need to be patient and don't think that it's just the panacea. But this should not discourage, I think, participants to try to use this, because the European regulators are eager to have the first GDPR code of conduct approved.
And
So,
we have many, Dan and Soren, do you agree with that?
Yeah,
Yes.
I just want to jump in. So I think that there is going to be significant room for self-regulation, and it is incredibly important moving forward. We are going to see an increase in GDPR laws throughout the world, right? We've seen that in California. And what we've seen are, in a lot of respects, certain regulators who don't, not necessarily regulators, but the proponents of the laws, who put forth laws where they don't understand the technical issues and implementation areas that our industry does. So I do think self-regulation is incredibly important to continue to be advocates, because we understand the technologies and the use thereof better than most other parties. The other thing we haven't really talked about, but I do think comes into the context of self-regulation, is regulation by platforms, right? So a really good example here is the new iOS 14 is actually going to have opt-in now for IDFA for certain types of tracking through apps. So again, there is definitely room for regulation, whether or not it's regulation that comes from within the platforms or the browsers themselves. But I do think that the industry as a whole needs to continue to take affirmative action to move forward protecting rights, because if we don't, we'll have regulators who step in who don't understand the technologies the way we do.
Soren, anything to add to that?
Yeah, just a little bit. For Germany, of course, we do not have a big and long tradition for self-regulation, because everything in Germany seems to be regulated by the legislator, which is not really astonishing. But and then second, to comment on what Cecilia said again, it is right that the GDPR contains already a huge and very specified set of rules, so that it might be really worth for some of the industries and industry organizations and associations to maybe clarify some or give some guidance to how to apply the already specific rules that are contained in the GDPR.
I have a very interesting question here. We haven't talked about this. Do you know of any survey that indicates how much interest consumers have in private data and the importance of privacy data, and how privacy is counted as a value to consumers? Is there some survey or piece of research on that you're aware of?
In Germany, people are very hesitant in giving away their data in Germany, and this is how everything got rolling, like in the 80s, when the first census, or when a big census was going on here. And I think there will be hesitant, and even nowadays there will be, even with GDPR. And what I have found out through many talks that I had with people is that cookie consent is a big thing here, and they're all annoyed about it because they always need to click it away. So I'm really looking forward to the crumble of the cookie here.
Dan and Cecilia?
I'm sure, Carla, that there are specific surveys. I haven't seen it. I will tell you that, generally speaking, awareness of privacy is significantly up in the United States. And if you go back just a few years, if you were to say, what do you think about companies collecting your data? The response would go, I don't really have anything to hide, right? But what we've seen over the last several years are incidents which have, whether or not influence presidential elections or demonstrating that data can be used in other ways at an aggregate level that individuals don't necessarily understand or have previously seen, I think has created this significant impact in awareness and concern around privacy rights in the US.
I have a note here that was sent to me that EDAA actually has such a survey. I haven't seen it, but I thought I would mention it since an audience member sent me a private note. So that's kind of interesting.
I have maybe something that may contribute. When the GDPR was in the negotiations in Europe, that we have a service of everything, I would say, which is called the Eurobarometer on very different issues, and definitely data is one of them. But something that you can also see is that there is a difference between what people say and what people do. So maybe you are saying, oh yes, I care definitely about my privacy, but then when you go online, or when you go to a restaurant, or well, when we went to a restaurant, because it is no longer possible in certain places, you actually do not, it is not coherent what you are saying with what you are doing, and then you are providing your data, you're not checking actually a privacy policy, you're not even asking what is the purpose of this. So I'm not really sure as to whether the surveys are really a good illustration of what really people are actually doing with their day-to-day life.
The reality versus the survey and what we talk about. I have a speed round question here. I'm going to have this as the last question of the panel. We're about to sign off and hand it back. This is a speed round question, and I'm going to ask every panelist for a yes or no question. This is something completely different. So let's think about what's next. What should we be doing? Is marketing, here's the question, is marketing on a collision course with all these privacy laws and regulations? We have a 2-volume set now with all these different privacy laws. Are we on a collision, is marketing on a collision course between law, consumer expectation, and marketing opportunity? Yes or no?
It is not a collision course, Carla. So I would say it is an exchange that is under test.
Okay. Anyone else? Cecilia, collision course or not?
Even if I am Spanish, I'm like quite German. And so if I receive an instruction of yes or no, I tend to think that I need answer yes or no. So I would say yes.
It's an easy question on the test.
I would say no.
I think it's a good, healthy compromise.
Yeah, I would say no as well. I think as long as, again, as we as an industry are thinking forward about trying to tackle these really tough issues, we can definitely avoid the collision course here. But it is really important to think through those issues.
And G-Man and Sundar and Soren?
I said no, and then I stick to that. That's fine.
Yeah, okay. G-Man?
Yeah, it's a no. I think it's a value exchange that needs to be revised.
And Sundar?
I think it has to be a good, healthy compromise between what you need to do and what the law is saying. So I think actually you got to take the right path.
Well, this has been a lot of fun. Thank you, Dan, Cecilia, G-Man. Thank you, Soren and Sundar. It's been a fun panel. It's been a quick but great discussion. We could go on for hours. Thank you, everyone who's joined us through the magic of YouTube. We really appreciate you being with us today. Follow GALA and IAA on social media. Follow all of us on social media. We're all on Twitter and LinkedIn. Join the IAA. Get your free copy of this book. It's an amazing book, the first of its kind. And let's all pray for a vaccine so that next time we get together, it's in person. So over to you, Prisha. Back to you. Thank you very much, everybody. Bye-bye.
Thank you, Carla, and our wonderful panel for putting so much of the conversation in context of the world that we are living in today. This discussion is going to help marketing professionals all over the world. And now, for our last speaker for the day, who will propose our vote of thanks, IAA Senior Vice President, Mr. Joel Netty. Over to you.
This has been a great event. Who would have thought? A little over a year ago, a few of us from the IAA paid courtesy calls, if you will, on various industry bodies in New York. And one of those visits was to GALA, where we met Jeff, and Jeff warmly welcomed us, and we had quite extensive discussions about what GALA was doing already and what the IAA was doing, and how we could collaborate, especially in the privacy space, but also along several lines. That's when this conversation about launching a book started. And I'm proud to say that following GALA's lead and partnering with IAA, today this book has been launched. Who would have thought when we met in New York that this would happen within a year? And even more so, who would have thought that the world would have changed so drastically that it wouldn't be a live event, but it would be a virtual one? And who would have thought that a virtual event, a virtual book launch could be so seamless? But it tells you what great minds, great organizations working together with a single purpose, single focus can achieve. And so today I want to thank Jeff, first of all, for welcoming us and together with the entire team at GALA, agreeing to partner the IAA to achieve such a great goal. I also want to recognize our special guest for today, Nitin Paranjpe, the CEO of Unilever. Thank you so much for making time to join us today. We've also had a wonderful panel discussion, and so I want to recognize our own Carla, who moderated the panel discussion, but also definitely our panelists, Daniel, Cecilia, and Jiman. Thank you so much for making time, and thank you so much for enlightening us on the subject. This will not be complete if I don't recognize our own team at the IAA, led of course by our president, SWAMY, and our managing director, DAGMARA, and the entire team at our global office in New York, who've worked together with GALA to bring us an event of this nature. It's been great, but above all else, let me say a big thank you to each and every one of you who's made time across the world. So for morning for some people, afternoon for some people, evening for others, who've stayed up just to be part of this great event. This for me is just one of several, the first milestone of several events and collaborations that we'll be having with GALA. So look out for this. Thank you very much for joining us. See you soon.
Thank you, sir. Ladies and gentlemen, with this we do come to the end of this program. On behalf of IAA and GALA, thank you all so much for joining us. My name is Frisia, and whichever part of the world you are in today, stay safe, be healthy.